rise. The Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in case number 1CR18 0847 and CR19-0200, consolidated cases, State of Arizona versus Rafael Nadim Mendoza. Council, remind you that this oral argument is being video, not recorded, so we ask you to please identify yourselves at the beginning of your arguments as well as who you represent. Each of you will have 20 minutes to which to present your arguments. Appellant, as counsel, you're responsible to watch the clock and reserve as much time as you wish for rebuttal. Also, please keep in mind we've read the briefs. We've also conferenced the case this morning. With that, counsel for appellant, you may proceed.
May it please the court, I am Mike Picaretta representing Dr. Mendoza on the appeal. What we have here in this case is an unexplained failure by the state to comply with the criminal rules, which in regards to but really the most critical piece of evidence in the case, which is the synced up video. They failed to perform a known obligation under the criminal rules and under the case law. And the failure was then compounded when they were permitted to use the video 9 witnesses later in the trial. They presented essentially the key witness, the victim's testimony, 2 times without an opportunity on the second time to cross-examine. And by that I mean the video itself, which was a 1-hour, very friendly video where KS was in a room holding a stuffed animal, drawing pictures, and where the interviewer, in a obviously non-confrontational manner, drew out her story. And let me tell you this, I'm not criticizing the interviewer. And in fact, during the trial, defense counsel even congratulated him in front of the jury for the interview, that he thought it was fair. They then were able not only to play the video, but then the video was admitted into evidence and went into the jury room, where the jury then had a 1-hour statement, substantive statement, that was used substantively by the prosecutor. And if you look in the closing arguments regarding how critical it was, he mentioned the video 32 times in the closing and the rebuttal.
Counsel, question for you on that. Do you know if the jury actually viewed that video?
Well, I wasn't in the jury room. I know that the video went into the jury room, and presuming that they're a vigilant juror, presumably looked at it, especially when the prosecutor repeatedly referred them to the video, referred them to view the video on it. And so in the jury room, there is the video. It was admitted and went to evidence along with all of the other evidence, and you presume they were instructed by the court that this is evidence of the case and take your time, and they there. So I was not there. We didn't breach the jury secrecy, but it was admitted, it was played, admitted, went into the jury room during the deliberations. And
trial, I'm sorry, I didn't mean to cut you off.
No.
The trial counsel's main objection was the timely disclosure of the video, right? That was the objection made at trial.
yes,
It wasn't another objection, hearsay or something else.
Well, later, in terms of why they were playing the video, it was admitted on October 3rd during her testimony. There was a very brief discussion, and the judge's concern was, is this that you received the video, you received the audio, is this the same? And he said, subject to that being true, the video is admitted. But the actual video synced was not marked as a trial exhibit. It was not disclosed in disclosure. They discussed it at the case management conference. Emails were exchanged, and there was an agreement, which the prosecutors copied on, to provide it. Why he didn't, only he knows, but he didn't. And it wasn't marked before trial, and it was sprung upon them in trial. And this is critical because it lets the accuser testify twice, and in the most benign atmosphere possible. And the state's argument now, apart from the disclosure issues, which it should not have been admitted, legally, evidentiary-wise, the whole video should not have been played. And the state's main argument on this appeal is that it was offered not for the truthfulness of it, because the woman suffered, as you've learned, from a disease called PANDAS, which is an autoimmune encephalitis, which has a whole variety of symptoms at different times, staring, OCD symptoms, and it was actually in effect due to her medical records around the time that this event actually occurred.
So, counsel, wasn't that? I mean, that was the defense. That was the defense, right? That was the defense strategy to show that because of this medical condition, that KS was not accurately portraying what happened, that she dreamed that, she hallucinated that. That's the theory. That was the theory of the defense.
That was the theory that A, it didn't occur, and B, that her initial reporting to her mother and her grandmother, which began with, "Did you take off my clothes?" and indicated she was confused about it.
Is that not a general attack on credibility of KS?
I don't know if having a mental health problem is an attack on it. I think it was more bringing to the attention of the fact finder through her medical records that she was suffering from something, and some of the effects of PANDAS include not being able, dream wake confusion, confabulation, being subject to suggestive thoughts. And these are known effects of the disease.
But they were not evident on the video.
No, because they wouldn't be. Because
The video can't pick up what is going on in her everyday life?
No.
Why do we have the video?
The video can pick up if someone has a tic or if someone is sneezing, but the video can't pick up if someone is making a statement that's false and believes it to be false. All it can do is record her statements. There was not a claim that she was exhibiting the physical symptoms of the disease on the video. And let me say this too, if that was the reason, which it was not, that it would be admitted just to show that, the state would have asked for a limiting instruction. They could have asked a detective to view the video and testify about it. The state wanted that video for the substance. And look at the closing arguments, both of them. This is not just, there is small mentions of the video being used. Look, at that moment, you don't detect symptoms of PANDAS the next day. But for the most part, the video went right to the substance of her testimony.
But that was the purpose of taking the video in the first place.
Well, it was.
Isn't a case of you take one, you get the other?
Well, no, you can admit a video, or admit any piece of evidence, and it doesn't go to the jury room. You play it like a prior inconsistent statement.
That's for a recorded recollection. But that's not one of the theories. There's alternative theories, it seems, like the parties aren't on the same page, the court, and I'm not sure we're on the same page. I'd like to throw out something that hasn't even been briefed, I don't think, but that's 801D1B, B sub 2. I know the parties have focused on sub 1, but sub 2 says it's the statement is offered to rehabilitate the declarant's credibility as a witness when attacked on another ground. In other words, it's sort of a catch-all. I mean, and help me understand why that wouldn't apply here.
Yeah, well, let me tell you why it wasn't briefed. Because the state in their brief particularly if you look, I think it's page 17 in the footnote, indicated they were not raising on appeal. So that's why it wasn't responded to in the reply.
But wait, why aren't we obligated to affirm the trial court's reasoning if it's ruling, if it's correct for any reason that's sustainable under the law?
Well, but normally the parties on appeal have the opportunity to fully brief an issue, and the parties have an obligation to raise issues. Yes, if you want to look at that. But let me tell you why that doesn't apply, and hasn't been briefed, and we haven't had that opportunity. But two things. One, that rule changed in January of 2015. The events in this case occurred in May of 14, and there's substantive law that indicates that substantive changes in the rule of evidence that impact it are not retroactive.
So you're saying this is a substantive change in the...
Oh, yeah. And two...
How so?
I see you smiling.
Because I have another case that involves exact...
Well, I'm more than...
Substantive,
He could
we
use some
do.
help with that
We do.
case.
Yeah, with substantive versus procedural, educate
I'm
us.
willing to help you on all these things.
Briefly.
But the second thing, too, Judge, is that we just copied the federal rule when we did that. And the federal commentary to the change of the rule in January of 15 makes it very clear, saying this was not meant to substantively change the rule. The rule was changed so that if the evidence is admitted, it's not just for impeachment or rehabilitation. It could be used substantively. Now, I know that I only have a short amount of time, but the answer is in the federal comments to the rule that say why the rule was changed.
Okay.
And secondly, if that gets interpreted in a way that all of a sudden out-of-court hearsay statements come in during the trial, it cuts two ways. There are many defendants who give fully exculpatory statements, get on the witness stand and get attacked. And then the lawyer is going to say, well, what's sauce for the goose is sauce for the gander. Bring in the out-of-court exculpatory statements. And U.S. v. Tone, the Supreme Court, was very concerned about admitting these out-of-court statements for fear that that would become the focus of the trial. So I think in terms of A, it's not a prior consistent statement. And B, if it is, the judge has an obligation to parse the 1 hour statement and say, okay, she was attacked on this, this comes in. She was attacked on this, this comes in. Not just play the whole thing playing with dolls, drawing pictures. And none of that was done.
But did the trial counsel say, defense trial counsel say, Judge, we want you to go through this and parse it out? I mean, once it was decided to come in, was there an alternative objection to what you're just making right here?
There was just well, it was sprung on them, so in fairness to them, this was all new on October 3rd, was when they became aware of it and when the main argument occurred. But they weren't offering alternatives, they were just citing that it was inadmissible in total. And the state won the day with it's not admitted for its truthfulness. So at the end of the day, the whole thing came in, admitted for its truthfulness, the witness got to testify twice, and again, have her testimony only with no cross on the video into the jury room.
Okay, let's clear up some procedure here real quick for our standard of review. At what point did the defense counsel make sort of three arguments? Hearsay, 403, and confrontation clause. It's my understanding that those were raised for the first time in the Rule 20 motion. Had the video already been played at that point?
No, the arguments were made, there were three separate pages. They were made on October 3rd, which is volume 2, on page 20 through, next 4 or 5 pages.
Okay, October 3rd. Okay. So my question is whether there was a contemporaneous objection to satisfy the requirement. Otherwise, we're reviewing to bring that timely objection to the trial court before it was played for the jury.
Yes, and there was another objection on October 11th, 1918, on pages 38 through 45.
Okay.
I mean, this was
Thank you.
objected to. They were completely, they felt sandbagged. They felt that the rules weren't complied with, and it's threefold objection. You didn't disclose it, it was improperly admitted, and then on top of that, it went to the jury, like a trifecta of errors. No qualifying, no limiting, no just show the video, no parsing under it, and it was very, part of it, the problem is when it came in like that, the lawyers had to figure this out at the moment. What it should have been done is when they were asking for it 2 years previously, and recognize this is 4 years after the offense, 2 years after the indictment, then good lawyers file briefs, get responses, the judge analyzes it. This just, boom, here it is, very quick argument. They made the arguments on 2 separate occasions and were overruled. But I think it's important to look at how it was used in closing argument. And remember that this is a out-of-court hearsay statement. And in terms of prior consistent, look at the state's appeals brief on it when they indicated they are not asserting that. So no one briefed it on our side. And secondly, it doesn't fit in total that way. And this was critical. This is the most critical piece of evidence, the most critical witness, and who was able to testify 2 and likely 3 times when it's played again in the jury to a document that was not, none of the things that were cross-examination were in the video. So you have to remember what the lawyers did on day 1 of the trial while you're looking at a person being questioned holding a stuffed animal. It's just trial A was an ambush, B, it's trial by hearsay, C, it fits right into tone. There was no claim she was recently fabricating, no claim there was a motive. It didn't fit the traditional methods of a prior consistent statement. And then when you look at the rule and the reason for the change, it still doesn't. And this opinion is going to be important because if we're going to start having trials by out-of-court statements in the jury room, lawyers all over the state are going to do it. Because I know I would if I can get my client's uncross-examined statement into the jury room, put them on the stand, let them get crossed, say, oh, here it comes, the whole exculpatory statement. But it's not the way you try cases. You get acquitted or convicted from witness on the witness stand, cross-examine and leaves. And this tape was played literally 9 witnesses later, Judge. And they continuously objected to it. And I see I'm running out of time, so I need to reserve it. I mean, there's numerous other issues too, but in my view, this issue is a critical issue for Dr. Mendoza, who is a well-regarded physician with no criminal history, no complaints, OB/GYN, and was convicted primarily on this evidence that was improperly disclosed, improperly admitted, and no excuse has been made for it other than traditional lawyer excuse of blame the secretary, which hasn't worked since even when I began practicing.
Thank you, counsel.
Good morning, Your Honors. My name is Terry Chris for the State of Arizona. May it please the Court. The trial court did not abuse its discretion by admitting the forensic interview videotape, both because the trial court was not required to institute preclusion as a discovery sanction, and because the video was not inadmissible hearsay that violated the Confrontation Clause. Beginning with the first point, this court has previously defined abuse of discretion in this context as a situation where no reasonable trial judge would reach the same result. And here, I don't think we could say that no reasonable trial judge would think, in the absence of prejudice, that preclusion would be the only way to handle what occurred here.
Did the court even consider a lesser sanction?
The court didn't openly ruminate on other alternatives, but what the court did do was to say that there would be multiple days where the defense could view the video to make sure it wasn't different from the copy they already had. And in fact, the video played 5 days later. So there's really no reason to think that there was any prejudice on the part of the defendant here. I think it's important to keep in mind that the defense already had all the components of this video years before trial. They had the video visually, they had the audio, they were able to transcribe that audio and to impeach with it at trial. In their opening statement, they made characterizations about what was on the video when they said that the witness appeared confused. So there's really no reason to think that they were prejudiced in any meaningful way here, such that the only way to address the issue would be through preclusion. Preclusion is often considered a sanction of last resort. And although there are cases upholding a trial court's decision to preclude, I'm not aware of a case from this court or the Supreme Court overturning a trial court's decision not to preclude. And so it really prejudice is the linchpin of this analysis. Bad faith is less important, I think, because if we were to reverse in a case, and we're not conceding bad faith here, but even if there were bad faith and there were no prejudice, it would be tantamount to punishing a prosecutor with the remedy of reversal and appeal. In the prosecutorial misconduct context, we don't do that. And that is where the constitutional due process rights are involved. Here, we're talking about a non-constitutional rule of procedure, and it seems to me we wouldn't use the heavy-handed instrument of reversal to vindicate that purely as a punitive measure either. So in the absence of prejudice, there simply was no abuse of discretion. Moving on to the hearsay issue, simply put, there's no confrontation clause issue, even if we had hearsay, because the witness was subject to cross-examination at trial.
Counsel, let's clear up one thing. Does the state agree that there was a timely contemporaneous objection on hearsay, 403, and the confrontation clause, that those were timely objections raised in the trial?
No, I don't think so. I actually was looking through the transcripts while waiting to come up here, and it seems to me that the day that the state notices they're going to use the video, which is October 3rd, the objection is about disclosure, and I don't see another objection on the video until the Rule 20, which is a day after the video is played. And it is important that we have contemporaneous objections because the trial court could grant the objection and do something about it. If you object a day later, then the genie's already out of the bottle, and at that point all you have left is a mistrial, which is a much more heavy-handed remedy, which is why...
So what you're suggesting is, and I don't think you alerted the court to this in your briefing, but what you're suggesting is that our review on the issue of hearsay, 403, and confrontation clause should be a fundamental error review instead of harmless error.
Yes, I think if we were to look at the objections, that's the conclusion we'd come to. So the confrontation clause part of this, I think, is fairly straightforward. We had a cross-examination of this witness. The fact that her prior statements occurred at a different time, I don't think changes the confrontation analysis. The defense was able to recall her after the video played if they wished, or to even impeach her when she was up the first time around, knowing the substance of her statements in the interview, and they could ask any questions they wanted to about what she was thinking or saying at the time of the previous statement. If that theory of the confrontation clause were true, then even all hearsay statements, even admissible ones, would violate the confrontation clause because prior statements wouldn't be amenable to cross-examination. But the Sixth Amendment doesn't afford a right to cross-examine statements. It's to cross-examine witnesses. The witness was present and there was cross-examination. As for the hearsay part of the analysis, ultimately the primary way this video was admissible was for a non-hearsay purpose. The critical issue at trial was whether the witness suffered from the syndrome, PANDAS. And PANDAS, as the state's expert who was her treating physician testified, has observable symptoms. There's obsessive compulsive behaviors. In this particular witness's case, we had visual tics and sneezes, and the fact that she did not exhibit those the day after her disclosure of the molestation is good evidence that she didn't suffer from the disease. Is it by itself conclusive evidence? Well, perhaps not, but that's not the standard. We don't have to say that the video would conclusively show that she didn't have PANDAS for relevance purposes. It's simply enough to say it's good evidence that she didn't have PANDAS. And it seems a stretch to argue anyway that she would suffer none of her old symptoms and only new hidden symptoms that the video couldn't pick up. That's a fair argument at trial, but that's not an argument to defeat admissibility. At best, it would just go to the weight of the evidence and closing arguments. So we have the video primarily admissible for that state purpose.
So help me understand more precisely. You're saying under what precise rule was that entire video admissible?
The definition of hearsay under Rule 801, that a
801.
statement must be offered for the truth of the matter asserted.
801D1B1 or 2, or both?
Well, I think D1B 1 and 2 are about certain types of prior consistent statements. I don't think you have to get that far if you're stuck at 801 A and B and C about the definition of hearsay to begin with. I think it's C that says that hearsay is a statement offered for the truth of what it asserts. And here, the primary means of admissibility is that the particular substance of her statements is less important than the fact that she's not sneezing, she's not acting compulsively, she seems composed and isn't exhibiting her old symptoms of pandas and the symptoms that a doctor would expect to see when evaluating for pandas. In addition,
But how would we know that that's the way the jury took it? I mean, with the 32 times or whatever being referenced to the video in closing, and the video going back to the jury, how would we be assured that with no limiting instruction, furthermore, no limiting instruction, how would we be assured that the jurors didn't consider it for the truth of the matters? That's 1 hour of content. That's very damning to the defense, wouldn't you agree? I mean, how would we say that, make that statement that it only came in to not prove the truth of the matter asserted therein?
well, Your Honor, I think that the defense didn't request a limiting instruction here. That, I think, certainly would be a fundamental error review issue. And so I think it would be speculative to assume that they did. As the question that someone asked when defense counsel was up here earlier was, how do we know that the jury viewed the video or not? And we don't know they viewed the video. But one thing we do know is that there were a few gaps in her trial testimony that would look like they were being filled in by the video substantively, which may have been admissible for past recollection recorded, but more importantly, all of those acts ultimately result in acquittals. So if you look at why the jury's acquitting, the acquittals are occurring because there are a few acts that the witness couldn't remember at trial, but remembered or talked about in her forensic interview. Those all resulted in acquittals. If we were worried the jury was considering the video for its substance, I don't think we would expect to see that. Now, that either means they didn't watch the video or they didn't give it undue weight, but at any rate, it certainly wouldn't be fundamental error for the lack of a limiting instruction. And also, I think generally, when we look at harmless error review, we can also consider the evidence in this case. We have the defendant's DNA on the victim. We have what I think is a fairly weak defense in the pandas argument. Part of why I think the pandas argument is so weak is because the treating physician testifies that pandas doesn't go away on its own. It may ebb and flow, but ultimately, if you don't treat the bacterial infection that causes it, you're going to continue to suffer symptoms. So not only would the witness have had pandas symptoms the day after her molestation disclosure, she would have had them at trial, and frankly, she'd probably still have them now. And so the jury was also able to observe her during trial to see if she's exhibiting symptoms. Because of that, the pandas argument, and not only that, but hallucination's a fairly rare symptom that she never had before. There's not any diagnosis that she's ever had a pandas relapse. And even though she had other medical issues at the time on the molestation, there's no proof that she actually was exhibiting a relapse other than speculation. So you also have the suspicious statement the defendant makes when the witness goes to disclose to her mother, where he says, wait, I can explain. I don't know what you would have to explain if there was nothing that occurred and she had hallucinated the event or confabulated it. So when you put all that together, at minimum you have harmless error. I would also say that the worst thing the jury could do with this evidence is consider it for essentially the same logic as a prior consistent statement. And prior consistent statements are generally cumulative evidence. They're, even though the rule guards when they can and can't come in, it's ultimately not going to be all that prejudicial because the jury heard what happened at trial, and especially in this case where we know the jury was paying attention between what was disclosed at trial and what was disclosed exclusively in the interview.
Counsel, help me understand again why it was appropriate for the video to go back to the jury to begin with in its entirety.
Well, if it's not hearsay because it's offered for a non-truth purpose, then there's no prohibition of it being admitted into evidence. And really what the video's non-hearsay purposes is for the jury to see and hear that this witness is not exhibiting the symptoms of pandas. I think you need to see and hear that. If the prosecution had tried an alternative means, it would not have been as good evidence. Having the detective who couldn't remember these things refresh his recollection and then give an after-the-fact assessment of whether he remembers her acting compulsively, which is a fairly subjective assessment, wasn't as good evidence. Watching the video with the sound turned off wouldn't give you the same effect either, because even though you could see whether or not she's physically sneezing, it would be really hard to tell if she's acting compulsively or exhibiting a few of the other symptoms. So at the end of the day, the best way for the state to show that the witness isn't suffering from pandas is to let them observe the witness not suffering from pandas. Also, I think if you would cut the video off too early, there would always be a danger that the jury might think, well, she didn't show pandas in the 30 minutes that they showed us, but there's another 30 minutes out there that we don't get to see, and maybe it's in that, which could, of course, be reasonable doubt. So,
So the flip side argument then would be that they redacted out anything that made it appear that in fact she was suffering. Is that what you're saying?
I'm saying that the jury might speculate as to why some of the video wasn't shown, and that speculation, or that, whatever you want to call it, might not be favorable to the state. So it's in the state's best interest to just put the whole video in front of them and say, this is all we have. Look, we don't see any pandas, and if she doesn't have these symptoms, that probably means she didn't have pandas at all. So I think absent hearsay, and at any rate, with any error being harmless, there was no abuse of discretion in the court's decision to admit the evidence. Unless the court has any questions about any of the other issues.
I'm sorry if you already touched on it, but what about the 403 objection? Why, given the overall context and I mean, it's obvious that the state wanted to rely on this video and wanted to rely on it heavily. So why wouldn't that be considered unduly prejudicial?
I think the simplest answer is all the reasons that I explained why this is harmless error would also show why it wouldn't violate Rule 403. It's really hard to do a 403 balance on appeal, especially when again, there wasn't a contemporaneous request for the trial court to do it until the Rule 20. But the standard is actually harder to succeed under Rule 403 because you don't just have to show there's some prejudicial value. You have to show that it would substantially outweigh the probative value. I think the probative value of this evidence is very high. Pandas was the key issue in this case. The defense never argued that the witness was lying or didn't believe her own statements. So in order to succeed, they had to show that she was confabulating and confused and hallucinating and acting delusionally, which entirely depended on whether she had this disease. And whether she suffered from the symptoms the day after was really strong evidence about whether she had the disease. Again, it's theoretically possible that she could suffer none of her symptoms previously and have all new hidden symptoms, but that's not a terribly compelling argument. And so under 403, we have very strong probative value. And again, the prejudicial value seems really small to me because even if the jury considered it for a substantive purpose, the worst they could do was to consider it as a prior consistent statement rehabilitating the witness's character, which is exactly what 801D2B2 allows them to do. And so I just don't see there being a lot of prejudice to outweigh the probative value. Absent further questions, we respectfully request this court affirm the convictions and sentences. Thank you.
Thank you.
Can I have his 5 minutes?
You left yourself. That's the way we think of it.
Judge, a couple of things that came out here. One, this court always has the duty to reverse any conviction where the defendant didn't get a fair trial. Secondly, their main argument, it wasn't offered for the truthfulness of it. How in the heck does the jury know that? No one told them that. They're argued the complete opposite in all the closing arguments. And now we're saying, well, this is why it's good. It wasn't for truthfulness. Well, he was convicted on the basis of the truthfulness of those statements. And just look at the arguments.
But no, there was no request for limiting instruction, was there?
Because the judge, well, first of all, there's two things. The judge admitted it substantively, which was a mistake. When you read the objections, and by the way, you can, there was an objection on October 11th. I mentioned earlier pages 38 to 45. In addition to October 3rd, beginning of page 20, so there was contemporaneous objections. But secondly, the court, and there's a case we would have briefed had they raised it, State v. Taylor, 196 Arizona 584, where the state failed to include a videotape in its Rule 15-1 disclosure and its untimely motion in limine to use the tape on the first day of trial. We cannot fault appellant for not making more specific objections. And that's at page 587, paragraph 5. I mean, that's why all this just sort of happened and came up, because of they didn't follow the rules on the most critical piece of evidence. And even to this day, we haven't even heard an explanation.
Counsel, to that point, there's no claim that the content of the video, the audio, or the video itself is any different than the second.
No, they could have used, the transcript was used in proper way for prior inconsistent statement, impeachment, didn't go back to the jury room. The video could have been used there, but what they can't do is tell the defense, we can't sync it. Let the defense make an opening statement, put the witness on the witness stand and go, oh yeah, by the way, it was synced. It wasn't on their witness exhibit list that all the judges make you fill out before trial. That's where the problem is, because it's much more compelling statement if it's all synced up so they can watch it. Everyone was under the impression that that was not an exhibit and wasn't in existence and not to be used at trial. Now, if they purely, I don't think the judge probably should have admitted the unsynced version anyway, for the reasons we've already discussed. But in any event, they can't admit an exhibit that they shouldn't have. And my time is up, and I just urge the court to reverse this conviction. The gentleman was tried on out-of-court hearsay statements that should not have been put into the jury room. Thank you.
Thank you. Counsel, thank you both for your helpful arguments this morning. The court will take this matter under advisement and issue a decision in due course. The court is adjourned.